Good afternoon, everyone. Welcome to the 2021 Trust and Estates series presented by the Northeast chapter of Association of Corporate Counsel and the private client attorneys at Nutter. There will be 3 webinars in this series. This is the first one, titled Why You Need an Estate Plan and Steps to Getting the Right One in Place. You will see the titles of the other 2 webinars at the end of this program, and I think they're also contained in the invitation to this webinar that you received. My name is Julia Cosentino, and presenting with me is my partner and current deputy chair of our group, Sarah Curley. The 2 of us will be with you for a little less than an hour. If during our program you have any questions, we ask that you please put them in either the chat box or in the Q&A box, and we will respond to them offline after the program is finished. Before we dive into the substance of the program, we just wanted to give you a quick snapshot of our team here at Nutter. I think the best way to sum up this particular slide is to say that we have a full service private client group that can help you and your family at any stage of your planning during lifetime, and also can assist with probate and trust administration after death. The second thing I want to say is we want to thank the Association of Corporate Counsel for this opportunity to present to all of you, its members. Nutter has been a longtime supporter of ACC's Northeast chapter, and we look forward each year to the annual event we host in Nutter's Seaport offices. This year, however, we must be content with connecting virtually through this 3-part webinar series on estate planning. I'm now going to turn the floor over to Sarah.
Thanks, Julia. We often hear people say that they want to get their affairs in order. And usually what they mean by this is that if they were to become incapacitated or on their death, they want to make things as easy as possible for their loved ones. And they also want to make sure that their wishes are known and carried out. One of the important steps to accomplishing this is to put in place the legal documents that appoint an agent to act for you if you become incapacitated, to appoint agents who can act on your death, and to provide for the disposition of your property on your death. Today, we are going to review at a high level 4 things. First, we're going to talk about what do we mean by an estate plan and why is it important to have one. Second, we will talk about what documents are part of a core estate plan and what role each one of these documents plays. Third, we'll give some advice for people who are in different life situations. We will look at an unmarried adult with no children. We'll look at a couple with young adult children, and we'll look at an older retired couple. And finally, we're going to give you some recommended actions that you can take to be prepared. Estate planning is a very broad term and covers many different things. For today's presentation, we are going to be concentrating on what we call a basic estate plan. And that has 5 main goals. First is planning for incapacity or disability. And by this, we mean naming an agent who can take actions for you or make decisions for you if you are unable to make or communicate actions yourself. Now, I should note here that sometimes people think of incapacity or disability planning as including what we call Medicaid planning. That is a specialized type of estate planning where the goal is to structure your assets in such a way that you would qualify for Medicaid, which is a public health insurance program for low-income people. We don't do that kind of planning at Nutter, but mention it here only because there are so many advertisements on the radio and such that we wanted to let folks know where that fits in. A second goal of estate planning is to allow you to direct who gets what and the manner in which your intended beneficiaries will inherit property from you after you die. A third goal of an estate plan is to allow you to nominate somebody who can be in charge of your estate after your death, so can administer your estate, and also to nominate guardians of any children who are minors or incapacitated at the time of your death. A fourth goal is to minimize taxes. And today we're going to talk about how using trusts can save Massachusetts estate taxes for a married couple on the death of the second spouse to die. And finally, an estate plan can provide some creditor protection for your family members after you have died. The first step in estate planning is to know what type of property you own and what kind of planning may be available or appropriate for those types of property. And there are four main categories of assets. The first is property that is held in your individual name. And as we will discuss, this is sometimes referred to as probate property, because on your death, this property is going to be controlled through the probate process, which Julia will talk about shortly. While you're alive, this property obviously can be controlled by you, but also may be controlled by an agent under a power of attorney. The second category are assets that are held jointly with somebody else. Now, the particular attributes of the joint ownership are going to determine the precise form of ownership here. But most joint property, or the property that we're going to be talking about today, is joint with rights of survivorship. That property can be controlled by any of the owners during lifetime, agents of any of the owners during lifetime, and on death, it passes automatically to the surviving owners. And the fourth category are assets, the third category are assets with a beneficiary designation. So these are things like life insurance or retirement accounts or transfer on death accounts. And these during lifetime obviously can be controlled by you or by an agent. And on death, they will pass pursuant to the beneficiary designation. And now the fourth category are assets that are held in trust. And those are controlled by the trustee in accordance with the terms of the trust instrument. And I'm now going to turn it over to Julia, who is going to talk about the components of an estate plan.
Thanks, Sarah. Okay, so we're hoping that all of you are here because you are thinking that maybe it would be a good idea to get an estate plan or update an estate plan that you signed many years ago. Before I get into these documents, these are what we consider to be the parts of a core estate plan. I just want to debunk two myths. The first one is we have some folks come to us and say, my wishes are very simple. All I need is a will. Well, that isn't exactly what we consider to be an effective estate plan. You need more than just a will. So that's the first myth. The second myth is other folks think trust isn't right for me. A trust is only for the very, very, very wealthy. Well, hopefully you will learn as part of this program that a trust is right for just about everyone. So we hope that you will approach it with an open mind. So now let's get to the four components of an effective estate plan. There are four documents that we consider as what you should have. This is the core plan. The documents number 3 and 4 here, they work together during your lifetime so that healthcare decisions and financial matters can be handled if you become incapacitated. 3 and 4 are actually more disability planning documents than maybe even estate planning documents. 1 and 2, the will and the revocable trust, they work together as well, but they work together after your death to be sure that your property passes among your loved ones or charities you may care about in exactly the way that you want. So even though on the screen, you'll see that the only document that has revocable next to it is the trust, in fact, all 4 of these are revocable. You can change your mind about their provisions as many times as you want, so long as you stay alive and competent. So if a couple comes to me wanting an estate plan, I hope that when the process is done, each will leave with 4 documents. And so for the 2 of them, that is at least 8 documents in total. Now I'm going to get into the details of the will. All right, so what exactly does the will do? The will is actually a very simple, straightforward document that accomplishes 2 or 3 main tasks. I actually want to cover task 2 and 3 before I get to the first one. So the will names your personal representatives. A personal representative is the current term for executor. This is the term that's used under current Massachusetts law. The job of the personal representative, or PR, is limited in time and it's limited in scope. The job lasts for 1, 2, and maybe even 3 years, and the duties are very clear and regimented. The PR submits the will for probate, collects the probate assets, sells whatever needs to be sold, pays the debts, administration expenses, taxes if taxes happen to be due, and then distributes the property as the will provides. So that's the personal representative. But if you, the client, have minor children, you will also want your will to nominate guardians of those children, children who are either minors or who otherwise lack capacity. When guardians are named, often it may be the other parent, not necessarily, but often. You'll want, though, to be sure that successors are named too. So for both the PR and the guardians, successor appointments will be important to have. And now I want to loop back up to the first main thing that the will does, and that is it disposes of your probate property. Sarah has already explained what probate property is. It is the property that you own in your individual name. So it's the bank account in your sole name. It's the Peloton you bought for yourself during the pandemic. It's the investment account with only your name in the title. The typical will actually only distributes the personal belongings to others. Like you name people to receive your personal belongings. So this is the furnishings in your condo, the Peloton I just mentioned, your car, jewelry. In your will, you say which individual should receive those things. But then the will directs everything else. So this is the balance of your probate property. The term is the residue of your estate over to your trust to be dealt with there. And truth be told, the trust is where the real action happens in your estate plan. So I'm going to give you a quick snapshot of what a simple will would look like. But before I do, I just want to explain to you what happens if you die without a will. So if you die without a will, your joint property will pass to the joint owner automatically by right of survivorship. An example is the house that you own with your spouse as tenants by the entirety. You die, that house will pass to your spouse automatically simply because he or she survived you. Any insurance policies or retirement accounts that you have, they will pass to designated beneficiaries, or possibly your estate, but hopefully designated beneficiaries. And then your probate property. This time, because remember, you don't have a will, that will pass according to the laws of intestate succession. So for those of you who are interested in Googling what the Massachusetts laws of intestate succession are, you can find them in General Laws, Chapter 190B, Article 2. And as you read through that, you will see that they represent the Commonwealth's best guess of what people would want to happen with their probate property in different factual situations. There is one provision that deals with if you die with no spouse and no children. Different provision if you die with a spouse, no children, but a living parent. Entirely different provision if you die with a spouse and children, but the law could operate differently if the children are yours with your current spouse, or if you have a prior relationship and you have children from that relationship. The law can also be different if you die with children only, no surviving spouse and no surviving parent. Let me just take one of those factual circumstances and give you an example of that and how the law plays out. So if you die with no children, but with a surviving spouse and one or both living parents, the law provides that the first $200,000 of your probate estate, plus 3/4 of the balance of your probate estate, will pass to the surviving spouse. But 1/4 of that balance will pass to your living parent or parents. So hearing this, you may say, that's great. That is exactly the way I would have wanted my property to go anyway. But you could hear this and say, well, no, in that situation, that's not how I would want my property to go. And if that's how you feel, then that is definitely a reason why you would want an estate plan. So now let me give you an example of what the provisions of a very simple will would look like. All right, so this is my very simple will. This is what it says. So I leave my personal belongings to my spouse, but if my spouse does not survive me, I'd like those belongings to pass among my children equally. But I actually do have some very specific wishes about my books. I have rare books and I know which child I'd like each book to go to. So I'm going to leave with my will a side letter. This is not mandatory, it's just for guidance. I'm going to leave it for my family so that they can know which book I would like to go to which child. Side letters can be common for distribution of personal belongings because I can change my mind and it's very simple to change a side letter. So that's for my personal belongings. Then I don't go into much more detail about bank accounts, investment accounts. I just say the residue of my estate to my revocable trust. I name my spouse to act as PR of my estate, but if my spouse isn't around or can't do it, I'd like Sarah to handle that job. And then I say that for my minor children, I'd like my spouse to be guardian, but if my spouse can't act for any reason, I'd like my sister-in-law to take over that responsibility. And that is what a simple will would look like. And now let me turn it over to Sarah to describe trusts for you.
So there are many different types of trusts, which have different attributes and characteristics and serve different purposes. Today, we are only going to be talking about revocable trusts, which are trusts that are revocable and amendable by the person who created it. Trusts straddle lifetime and death planning, and they are by far the most complicated and foreign concept for many of our clients. I sometimes say trusts do not exist in nature. We talk about trusts as though they are entities, But in fact, a trust is a fiduciary relationship, and it is among the trustee who holds legal title to the property, the creator of the trust, and the beneficiaries who hold the beneficial ownership in the property. A revocable trust can be, but does not have to be, funded by the person who created it during their lifetime. And by funded, I mean title the assets in the name of the trust. So for example, if I have an investment account and it's currently titled just Sarah Curley, that's the name that appears on the account statement, and that's how I opened up the investment account when I created it. If I wanted to fund my trust with that account, I would retitle it into the name of Sarah Curley as trustee of the Sarah Curley Revocable Trust. And I've now funded my trust. If you don't fund your trust during lifetime, then that's fine. It's just basically a piece of paper or a stack of papers that will lie dormant until your death. And then, as Julia described, on your death, the will might pour property over into your trust, or maybe you have beneficiary designations like that life insurance policy or those retirement benefits that name the trust as the beneficiary. And that's how the trust will become funded on my death if I hadn't funded it during my lifetime. From an income tax perspective, while I'm alive, my revocable trust is the same as me. So back to that investment account example, if I have an investment account that's titled in the name of my trust, and I've got some stocks and I sell those stocks and there's capital gains, those capital gains are going to be reported on my personal income tax return. So my Form 1040 is going to reflect that. And during the course of the year, if there's interest and dividends, all of that gets reported on my income tax return. There's no difference during my lifetime between my trust and me. Similarly, from a creditor perspective, if I were to be sued, the creditors could reach the assets in my investment account that's titled in the name of my trust just as easily as they could have accessed it if it was titled in my own name. In other words, my trust provides no creditor protection for me during my lifetime, assuming that it's my revocable trust that I created. So at this point, some of you may be asking, well, then why bother with a revocable trust? So there are a few advantages, and different people put different weight on how important these advantages are for me during my lifetime with respect to the trust that I created. So one is it gives an opportunity for property management. So for example, if I fund my revocable trust, so it's that I put that investment account in the name of my trust, and then I resign as trustee, and Julia comes on as the successor trustee. Now it's Julia's responsibility to manage those assets for my benefit. She could hire an investment manager. She doesn't have to do that herself, but she can also arrange to have my bills paid. So, she's a very generous person, but she would be using my money to pay my bills. And that would be a way for management of my assets. Another potential advantage for some people is that by funding my revocable trust during my lifetime, I can avoid or minimize probate on my death. In other words, I can make the process a little bit smoother and a little bit easier for my family that I leave behind. So back to my example, if I had resigned as trustee and Julia was acting, the day that I die, she could use those trust assets to pay my funeral bill, or she could use those trust assets to pay other debts or expenses of my estate. A trust is also a good tool for people who are concerned about privacy. When a person dies, their will is probated with the probate court and it becomes a public document. And many of us have seen, right, when celebrities die and their will is on all the tabloids and all over the internet. And that's because those are public documents. A trust, however, is a private document, so that can't be shared with the world. It doesn't get filed with the probate court. Perhaps more significant, though, than the benefits that a revocable trust provides to me as the creator during my lifetime are the benefits that it gives to my family after I die. So one of those benefits would be for married couples. So a married couple, if they're Massachusetts residents, can use the trust, a revocable trust, in order to ensure that each spouse is able to take advantage of the Massachusetts estate tax exemption. And I'm going to get back to this bit in a little bit, but just kind of file that aside for the moment. Another advantage to my family is if I were to have minor children, or if I wanted to benefit minor children in my estate plan. Without a trust, there's pretty much two options. If I leave property on my death to a minor child, either that property would go into an UTMA account, that's the Uniform Transfers to Minors Act account. And in that case, the property would be accessible by the minor child upon attaining age 21. So at age 21, they can take everything out and do whatever they please with that property. The other option would be that a court-appointed conservator would come into play, and that's appointed by the judge, so that would be part of the probate administration. The judge appoints a conservator, and then the conservatorship is within the jurisdiction of the probate court. They have to account on a regular basis. It's public. It's oftentimes a little bit more expensive. There might be a surety bond or something to ensure the proper performance of the fiduciary. And it's just at age 18, the minor child then could have everything distributed to them. So one of the significant parts of estate planning is trying to think about these very worst case scenarios and tragic situations and to have some control over it. So if parents were to die while their children were minors, or if somebody wants to leave an inheritance to somebody who's a minor, let's think about what kind of management and control we want to have over those assets, and do it in a thoughtful manner, so that if we think that a child, even the best of kids, when faced with these really tragic circumstances, they might need a little bit of extra help or a longer period of time before the parents think that the child would be able to manage finances on his or her own. A trust also allows the creator to control what happens to the property. Some of you may remember from law school the concept of the dead hand reaching from the grave and controlling what happens. It doesn't always have to be that negative, right? Control isn't necessarily a bad thing. For example, I have a vacation home up in New Hampshire, and after I die, I want my brother to be able to enjoy that property. But I don't want him to sell it and pocket the proceeds, or I don't want him, if he were to die after me, but before his wife, I don't want him to leave it to her, because maybe I have other plans for what I want to have happen for that property. And by using a trust, I can control that. I can say what happens. I can put conditions about whether it's sold, and if it is, maybe I want to say if it's sold, it goes to a conservation organization up there. But you get to decide those things yourself. Another thing that a trust can do is sometimes people want to incentivize or encourage certain behavior. So you can do that by use of a trust. You can put conditions in or put wishes in to encourage a certain form of behavior from the beneficiaries. Or another very tragic thing that we've seen, sometimes we've got people who want to benefit somebody who has a substance abuse issue or other mental health issues. And by leaving the property in a trust for the benefit of this person, you get to ensure that they have the positives that money can bring, right? They can get the treatment that they need. They can have a roof over their head, but you're not actually putting the dollars in their hands and risking that they could do something harmful to themselves. So that's another really great use for trusts. So earlier I said, with respect to me, if I put my money into a trust, it's not protected from my creditors. But the same is not true with respect to my family. If I put money into my trust and on my death, it goes into a trust for my children, then that money in the trust for my children is protected against my children's creditors. Now, creditors doesn't necessarily mean loan shark, right? It's not that my children are gamblers or there's something like that. A creditor could also be a divorcing spouse. So for example, after I die, if one of my children goes through a divorce, as long as that trust, my trust was properly drafted and properly administered, and it's still held in that trust property should not be subject to the divorce action of my child. It's not going to be subject to division as marital property. All right, I'm now going to go back and talk in a little bit more detail about how trusts can save the Massachusetts estate tax. But in order to do that, I first just need to give a brief overview on how the federal and Massachusetts estate tax regimes work. So currently, the federal estate tax exemption is $11.7 million per person. So that means that's the maximum amount that a person can leave to another individual, not including the spouse, without incurring any estate tax. And I just have two little asterisks here. One is it's actually $10 million indexed for inflation, and I'll come back to why that's important. And then the other asterisk is that it's actually a unified system. We have a gift and estate tax unified exemption. So I could either give it away during lifetime or it could pass on my death. But for today's purposes, we're going to ignore the lifetime gift provisions and we're only going to talk about the estate tax. Now, the reason that the 11.7, that it's actually 10 million indexed for inflation is important is because at the end of 2025, that exemption is scheduled, if Congress does nothing, to be cut in half. So it's going to go back down to 5 million indexed for inflation as of January of 2026. Another aspect of the federal estate tax regime is there's a 100% marital deduction as long as the surviving spouse is a US citizen. There's other rules for non-citizens, which is beyond the scope of our talk today. And then finally, on the federal side, there's a relatively new concept, which is called portability. And what this means is that if you don't use your federal estate tax exemption, you can essentially port it to your spouse if you're married. So if I don't use my federal estate tax exemption, as long as I follow certain, or my personal representative follows certain procedures, that exemption, that unused exemption, can be passed to my spouse. Now, on the Massachusetts side, there's essentially a $1 million estate tax exemption. And I say essentially because the Massachusetts estate tax is kind of a convoluted calculation, which we're not going to get into, but if there have been no prior taxable gifts, it's going to be a $1 million estate tax exemption. And for Massachusetts, it's use it or lose it. All right, so now let's talk about how by using a trust, a Massachusetts resident couple can save Massachusetts estate tax. So for these purposes, I'm going to assume a married couple. I'm going to call them husband and wife, and each of them has $1 million in his or her individual name. And they have a very basic estate plan that says I leave everything to my spouse if he survives me, and if he doesn't, everything goes to my children. All right, so let's say husband dies first. So he dies, his $1 million goes to wife. Fine, no Massachusetts estate tax, it's 100% marital deduction, so no tax. Now wife dies. She has $2 million. She's got the 1 million she got from husband, plus she has the 1 million that she had herself. So $2 million, which is going to her children. There will be a Massachusetts estate tax of $99,600 on her death. Now let's suppose that this couple had used a trust. So husband dies first again, but now his $1 million goes into a trust for the benefit of wife. So if wife needs those assets, she can access them. She's the beneficiary. And then after both husband and wife have died, those assets go to the children. So husband dies first, his 1 million goes to his trust. Fine, no Massachusetts estate tax because that is within his Massachusetts estate tax exemption. Now wife dies. husband's trust is not includable in her estate. His trust now terminates, it goes to the kids. Wife had $1 million in her name, that now goes to the kids. No Massachusetts estate tax because that's within the exemption. We just saved this couple $99,600 by using a trust. And again, I'm kind of oversimplifying the way the Massachusetts estate tax works, but if there were no prior taxable gifts, that's essentially how it would operate. And I'm now going to turn things over to Julia, who's going to talk about disability planning documents.
Thanks, Sarah. Okay, so we've covered the will and we've covered the trust. Now we're going to loop back to the disability planning documents. There are the two main documents that we had mentioned several minutes ago, and there are actually two more that I want to explain to you because it may be right for your situation. Let's begin with the healthcare proxy. So the healthcare proxy is the document by which you name a person to make healthcare decisions for you if you are unable to make those decisions or you cannot communicate your wishes. The person you name is called a healthcare agent. In Massachusetts, you can only name one agent to act at a time. This makes sense because if you're a hospital, doctors, you don't want to have to navigate a disagreement among multiple healthcare agents. You just only want one that you are to turn to. So if you're thinking of naming your spouse, well, then there's no issue. There's the one. But what if you want to name your children as successors to your spouse? Well, that's when you actually have to choose an order among them. It has to be one child named at a time. You could make the decision as to who goes first, second, third, depending upon maybe geography, which child lives closest. It could be based upon the children's professions. You may have a son who's a nurse practitioner. It also can be if one child seems to be more in tune with your thinking on healthcare matters than the others, but you still need to make the choice. Now, Massachusetts doesn't recognize living wills. However, within your healthcare proxy document, you can include a medical directive, which is like a living will in that it expresses your wishes for how you would like to be treated in different medical situations. This would only be guidance for your healthcare agent because your healthcare agent actually makes the decision, but it can give you peace of mind knowing that you have gotten those wishes across to him or her. So that's the healthcare proxy. Let's go to the other side of the disability planning coin, which is the durable power of attorney. So the durable power of attorney is the document by which you name someone to handle your financial matters. Now, this person stands in your shoes. The person that you name to stand in your shoes for financial matters is called an attorney in fact. There are actually two different types of powers of attorney, though, and I want you to be aware of that. One is called a springing power of attorney. That means it springs into effect when you are determined to be incapacitated. The durable power of attorney, by contrast, is something that can be effective from the moment that it is signed. Now, we tend to recommend the durable power of attorney versus the springing power of attorney for a couple of reasons. The first thing is that the durable power of attorney can also be used when it's just inconvenient for you to handle a financial matter. You could be traveling and then suddenly something needs to be attended to at home. Well, your attorney, in fact, could handle that for you under a durable power of attorney. Also, you may want the person you name to begin acting because you actually have gotten tired of handling your financial matters. You want to turn that responsibility over to someone else well before, if you ever become incapacitated, you're not now, but you want someone else to handle that, those jobs. You can do that under a durable power of attorney because, again, it's effective from the moment that it's signed. Before I get into why these things need to be refreshed every now and then, I do want to mention something that is a contrast from the healthcare proxy. For a durable or even a springing, but you can name more than one attorney, in fact, to act at a time. So those 3 children where you had to choose among them for the healthcare proxy, for the power of attorney, you could, if it seemed practical, have all 3 of them named to act at the same time, or they also could act singly. So just want you to be aware of that. Now, powers of attorney should be updated periodically. One reason is, I mean, when you hear what they do, they're very powerful documents. So financial institutions where powers of attorney are presented tend to scrutinize them very closely. If they see one that was executed many years ago, there's a chance that the financial institution will say that it's stale. Well, you don't want to have your attorney, in fact, confront that issue. The law doesn't say that a power of attorney becomes stale, but still, why should your attorney, in fact, have to deal with that hurdle? So our recommendation to our clients is to have them refreshed every few years. I mean, we would say every 5 years or so. So that's one reason to update them. The other is sometimes there are new provisions that should be part of a power of attorney, new powers for the attorney, in fact, under current law. An example of that is actually having to do with digital assets. So your digital assets are the photos you store in the cloud. They are your social media accounts. Your email, that's a digital asset. Bank statements could come only in via digital form. Well, to be able to act on those assets, your attorney, in fact, needs to be given specific authority. So if you haven't signed a power of attorney for a number of years, I would say look at that old power of attorney, and my guess is it will say nothing about digital assets, and you really want that to be included now. So those are the 2 main documents, but there are 2 others that I want you all to be aware of. The first is the HIPAA authorization. So I think folks are familiar with HIPAA. It's the Health Insurance Portability and Accountability Act. So this is the law that protects the privacy of your personal health information. You may want someone else to have access to that. So I would argue that for a healthcare proxy, your healthcare agent would have access to your personal medical information in order to fulfill his or her role. But a healthcare agent really only comes into effect if you are determined to be unable to make medical decisions or communicate your wishes on medical decisions. You may want to have your personal health information shared with someone else short of that. And if that does matter to you, you would want to sign a HIPAA authorization. The last document I want to mention is a MOLST form. So this is medical orders for life-sustaining treatment. There's a Massachusetts MOLST form that you can Google. And if you do, you will see that it goes into actually quite a bit of detail about what your wishes are in very specific medical situations. It can contain a do not resuscitate order. It can say whether you want intubation or ventilation, whether you want to be transferred to a hospital or you do not want to be transferred to a hospital, what your feelings are about dialysis, artificial nutrition, artificial hydration. So very detailed expression of your wishes for specific circumstances. If you are confronting a medical challenge, or as you age, getting those wishes across in this form may become important to you, so we want you to be aware of it. There are a couple of requirements though. The first is, you look at the form, you will see that it needs to be signed by a medical provider. So a physician, a nurse practitioner, or a physician assistant. The reason is that these decisions that you'll be making as part of completing this form really bear a discussion with a medical provider first, I would say. So the law and the form wants to know that that happens, so the medical provider must sign it. The other thing though is the form really should be printed in its final form on bright pink paper. The reason is that EMTs are trained to look for this form. So if you want to have it in place before you go to sign it and have your medical provider sign it with you, you will want to be sure that it's printed on that bright pink or fluorescent pink paper. All right, so we've gone through all of the documents. And Sarah, if we can just go to the next slide. Here we go. So we thought it would be helpful to you for us to just sort of step back a bit and explain where each of these documents fits in over the continuum of your lifetime, continuing into the estate settlement and distribution. So you'll see on this slide, we have the dividing line of death. To the left of that, so we have lifetime. The healthcare proxy operates during your lifetime, as does the durable power of attorney. However, at your death, those authorities stop. Sometimes we will have a client say to us, so I'm the decedent's power of attorney. Can I pay the funeral bill using that? No. The authority of the power of attorney ends at the principal's death. So on the right side of the line, after death, we have the will operating. If the will is filed in the probate court and it's allowed, it is deemed your last will and testament. This operates during the period of the estate settlement. That, as I mentioned before, could be 1, 2, or 3 years. It provides for your property then to go possibly distributed outright, but more likely it will be distributed through the trust. And then that's when the will's operation ends. The only document of the 4 that we have covered that continues throughout the whole arrow is the trust. If you decide to fund it during lifetime, it operates during lifetime. But then you'll see that it continues not only so after death, during the period of estate settlement, and then if you have chosen to have property remain in trust for a period of time for beneficiaries, it can continue well past that. All right. So now we want to go from the hypothetical, the academic, to dive into the practical. So we would like to just present to all of you 3 common client scenarios: an unmarried adult with no children, a married couple with 2 kids, ages 15 and 18, and a retired couple in their late 70s, and give you a sense of some pieces of advice that we would give these clients in each of these situations. So I'll turn it to Sarah.
All right, so the first scenario is the unmarried adult with no children. And the first piece of advice that we would give this person is it's especially important to have an estate plan in place. And there's a few reasons for this, as you've probably gathered from our presentation so far. First is you want to be able to control who gets what, and you want to be able to name or appoint somebody who will be in charge of administering your estate after your death. So if somebody is listening to this and says, no, I'm still not interested, we would just say, make sure that you understand the rules of intestacy and that you know the decision that you're making by not executing an estate plan. Now, for this person, a trust may or may not make sense. And there's going to be a couple of different factors that this person would take into consideration. One is kind of during that person's lifetime or their own personal goals. And that would be things like, how important is privacy? For example, if I'm just leaving everything to my friends, I may not want each friend to know what the other one is getting. And if it's just done in a will and not in a trust, it's going to be public. So everybody will know what everybody else is getting. But if I use a trust, I'm going to maintain that privacy because they're not going to see the provisions that don't pertain to them. Another thing to consider is the minimizing probate, which we talked about earlier. If I fund my trust during my lifetime, I can make things a little bit smoother and faster for my family after my death. The other thing, and I sort of touched on this a little bit, but it's whether or not a trust is right for me is also going to depend on who my beneficiaries are. If I am leaving everything to friends or family members, maybe siblings or cousins who are approximately my age, then maybe it is fine to just leave everything outright. And if I'm not concerned about privacy, I could just have a simple will that leaves everything outright. But if I'm leaving inheritances for nieces and nephews who are minors, or for friends, children of friends who are minors, then a trust may make sense. Or again, if I'm thinking about leaving property for somebody who might have mental health issues, maybe I would want to use a trust. Or maybe if I'm wanting to do some upstream planning, if my parents are alive and I want to allow them to benefit from my assets, but I don't want to artificially inflate their estates, right? In Massachusetts, if you own a home, it's pretty easy to get over that $1 million estate tax exemption. So if I leave my home to my parents, I might be creating an estate. I have an estate tax on my death, but if it goes outright to my parents, maybe I've just created an estate tax on their death. And then when they die, it goes to my siblings and then they have one. So a trust is another way that can avoid that. So that's one thing we want to emphasize. That's the first piece of advice is have an estate plan. And then the second piece, assuming that the person has an estate plan, we would encourage them to review closely the fiduciaries or the agents that are selected for the healthcare proxy, the power of attorney, the personal representative and trustee. So again, have an estate plan is number one. And number two is if you do have one, make sure that you review and are comfortable with those decisions.
And I will add a third piece of advice here, and that is, let's just think, so this unmarried adult may live alone. Well, he or she will want to make sure that the folks that they've named, so the attorney in fact or the personal representative, knows how to figure out what their financial documents are, what information is available. So please make sure, I would say to this client, that your records are easily identified and easily accessed. Digital assets can present a real challenge here. So I would also encourage this client to leave breadcrumbs, if you will, a list perhaps of online only accounts so that folks will know what truly is out there. All right. So we're going to move now to scenario number 2. So this is the married couple with kids ages 15 and 18. So let's start with the fact that one of their children is 15. So that child, still a minor, and if, God forbid something should happen, there would need to be a guardian nominated for that minor. So I would encourage this couple, this client, to be sure that their guardianship provisions are up to date. A will, let's say, may have been signed 10 years ago and named an aunt who lives way across the country. Well, Now, 10 years have passed, the 15-year-old has a life that very much is here with school and friends and organizations he or she is involved with. So it may be worthwhile to consider whether a different guardianship provision would be appropriate. So the first piece of advice has to do really about the 15-year-old. My second piece of advice is more about that 18-year-old. So the 18-year-old is considered an adult in the eyes of the law. So if something should happen where the 18-year-old is dealing with a health crisis and cannot communicate his or her wishes for medical care, well, who is going to do that? Because this 18-plus-year-old is an adult, the doctors aren't going to automatically turn to the parents, let's say. So in my mind, the period from 18 until when the child really does take the reins of their own planning can be a very vulnerable period. So what I did for my kids as they were going off to college is that I suggested to them that they sign a healthcare proxy, a HIPAA authorization, and a durable power of attorney. Do be aware that if your 18-plus-year-old is headed off to college, that college may have very specific forms that they would prefer to be signed in addition to or in lieu of, and that is mostly because of the FERPA rules, which is the federal rule that provides for privacy of a university student's school records. So be sure to look at what that child's or young adult's particular university wants, and you would want those to be executed as well.
And then the third piece of advice for this couple we have is review the trust provision. So obviously inherent in that is these folks should have trusts. We're assuming they're Massachusetts residents, they should have trusts. And this is really a good time to take a look and make sure that the provisions that they have for their children still make sense. And now we're going to look at the third scenario, which is the retired couple in their late 70s. And the first piece of advice for these folks is to be sure that their beneficiary designations are up to date. And by this, we mean take a look at, actually contact the institutions, the life insurance, the retirement accounts, and make sure that the beneficiaries named are still appropriate. And there's kind of two pieces to this. One is the considerations that go into who is named are pretty complicated. We did not get into that today, but let's just say that things change, right? As people get older and children grow up and they know, parents know different things about their children, they may make different decisions. So that's one part of it. But the other part of it is that institutions change too, right? They could merge or change their filing systems. So we've sometimes had occasions where people were positive that 40 years ago they did designate beneficiaries on an account, but now the financial institution can't find it. So this is a good time to just double check, make sure that it's there and make sure that it's right. And then a second piece of advice is consider whether it makes sense to fund your revocable trust. And we've talked a lot already about what that means and how you do it and why you might want to do it. The other thing I would just point out is that you could, rather than funding your trust during lifetime, you could put a transfer on death designation on one of those accounts. And so that way it would pass automatically pursuant to the transfer on death designation, rather than you having to go through all of the rigmarole and paperwork to fund the trust during your lifetime.
And then I will just add the third piece of advice for this client is really to think about your healthcare proxies and your durable powers of attorney, and perhaps start to have discussions with your kids. Does it make sense to try to involve your children or ask your children to be involved more, knowing about what your intentions are, and perhaps involve them more in your planning? So, all right, so we've left you with a lot of information. Here is a quick to-do list We do want you to know, though, that you will be receiving a communication following up on this webinar that includes a handout. This handout is called 7 Ways to Prepare for Your First Estate Planning Meeting. It will hopefully be helpful not only for someone who's thinking about having that first meeting, but also folks who are looking to update their planning. So this concludes the first of the 3 webinars. Here are the other 2 webinars coming up in June and September. So in closing, on behalf of Sarah and me, thank you for your attention. Thank you again to ACC Northeast, and we hope to see you in the Seaport next year.